article by Judge Connor of the same court. Trying to get justice on these lawbreakers has impoverished Glendora. Her only income is her Social Security check for $425 or so a month. Crooked lawyers and corrupt judges have taken away her time to get business for Glendora TV ads and wreaked havoc on her married life and church life. Robert Callaghy ordered a tape for $95 and has not paid for it yet, November the 95th to March the 96th, and Judge Bryant has ordered him to do so 5 times, just as he has been ordered by the courts to produce Cablevision's insurance agreement and is in contempt. This is the man who robbed Glendora of her victory costs in the Judge Silverman court, so Glendora will not be paying any costs. She does not have the money. Yours in truth, Glendora. Copy to Robert Callaghy. Here's the affidavit of service by Franklin. And here's the atrocious, unbelievable decision of the appellate division. And as I say, who's behind it all? The Nassau County Republicans. They put pressure on the appellate division to put pressure on Judge Silverman to change his decision, which is in my favor. We put the program back on TV, and now they want to get it off TV because they don't want you to know their record. Their record is bad, and they don't want me on television reading it to you every week. Now, we're going to stop for jokes. In the next program, we're going to read you Glendora's memorandum to Judge Silverman complaining about the way he handled the proceeding in court yesterday, March the 11th, 1996. Says that he buys sweet chariot stocks. The minute he buys them, they swing low. And Peter says, he's a broker, and he says, I'll tell you the truth. He says, you'd be amazed at the number of people who come to my office riding in a Lincoln with a chauffeur to ask for advice from a guy who comes to work on the bus. And Harry asked a neighbor, who is a big executive in the financial district, what's the latest dope on Wall Street? And the neighbor said, my son Irving, he started working for the company. Folks, this is a Nassau County edition of A Chat with Glendora, and we're reporting to you what happened on March the 11th, 1996 in the Judge Silverman courtroom. It was so bad that the next day I went out and wrote this memorandum to Judge Silverman. This is Glendora versus Kofalt, Dolan, Tata, Bell, Lustgarten, Randolph, Lemley, Asnara, Dolan, and Cablevision Systems Corporation. Donald N. Silverman presiding. Glendora had many topics to bring up at the conference she called on March the 11th, 1996 at 9:30 a.m. She never got the chance to say what she came to say. She spent 4 hours preparing for the conference and never had the opportunity to use any of it because Judge Silverman let Robert Callaghy do all of the talking and would not give Glendora a chance to present her point. Therefore, she presents him in this memorandum. Here's what she has to say. What was the time on that? Let's see, 4 hours preparing it, 3 hours there. I think it was 10 hours, the New York State Court of Appeals, and 10 hours on this. I don't think the New York State Appeals could have been. It would be 10 hours on this and about 6 hours on the New York State Court of Appeals. So that's 4, 7, 13, 23 hours. Judge Bryant was appalled with the decision order of February 13, 1996 of the Appellate Division, 2nd Department. They didn't even rule on the merits, he said. Another thing Judge Bryant said off the record, you all know that Silverman isn't going to change his mind. Judge Bryant said Judge Silverman's decision in order of July the 28th, 1994 was unassailable, quote unquote. Judge Bryant's memorandum and order made race judicata and collateral estoppel all of Callaghy's arguments to the Appellate Division, 2nd Department. Please see the following letter to the Appellate Division, 2nd Department pointing this out. And that's the thing that I just read you on the last program. It's the same one. Now, Mr. Callaghy berated Judge Silverman in his briefs to the Appellate Division, but it wasn't Judge Silverman who was wrong, it was Mr. Callaghy's malpractice. Mr. Callaghy had plenty of opportunity to raise his argument to Judge Silverman July 14, 1994, and give Judge Silverman a chance to answer, but Callaghy did not. Callagy lied that Judge Silverman turned Glendora's cross motion to deny defendant's motion to dismiss. Judge Silverman did not do this. He simply granted the cross motion. It was Callagy's malpractice not to get his arguments in. The Appellate Division, 2nd Department, is a court of review. Callagy was bringing things up in the Appellate Division, 2nd Department that he didn't raise in the Judge Silverman court. Both the Appellate Division and Callagy were wrong to do that. Judge Bryan overruled Judge Broderick. The Judge Broderick decision is dead. March the 11th, 1996, Monday, Judge Silverman is wrong again to have the defendant speak first. The plaintiff speaks first. Everything Mr. Callagy told Judge Silverman, March the 11th, 1996, Monday, was wrong or was a lie. What Callagy argued at the Appellate Division, 2nd Department, was not what he stated in his notice of appeal. How do you get by with that? Callagy forgot to go to the oral argument of the Appellate Division, 2nd Department on January 5th, 1996. Cablevision acted improperly as a matter of law. They violated Article 28, New York Executive Law, now Article 20 of the Public Service Law, 829.3. They have been convicted July the 19th, 1995 of breaking the federal law, Title 47, 531E, that says the same thing. No cable operator shall exercise editorial control over public use of channel. Thomas Geiger said on audio tape on November the 12th, 1993, Friday, 4:50 to 5:15 p.m. that the executives of Cablevision took the show off TV on content. The facts have not changed. Judge Bryan has already adjudicated July the 19th, 1995 that Cablevision, by putting her program on TV 6 times, had already admitted her right to be there. Judge Bryan has already adjudicated July 19th, 1995 that Glendora's residency has no bearing. Judge Van Graeflin, U.S. Court of Appeals, 2nd Circuit, ruled to the extent of conflict between state law and federal law must prevail. January 11th, 1995. Point 23, Glendora's case cannot be dismissed. And this was ruled by the 2nd Circuit, United States Court of Appeals. In view of the well-settled rule, particularly applicable in pro se civil rights actions, that a complaint should not be dismissed unless it appears beyond a doubt that the plaintiff can prove no set of facts in support of her claim which would entitle her to relief. Barnes v. Clark and Conley v. Gibson. Well, Cablevision has not proved beyond doubt that Glendora can prove no set of facts in support of her claim, which would entitle her to relief. Robert Callagy has been ordered to pay Glendora $95 for the tape. Callagy ordered of the Geiger conversation of November 12, 93. The court has ordered him 5 times to pay, and he has not. And this is the individual who robbed Glendora of her victory cost July 28, 1994 in the Judge Silverman court. The Appellate Division decision makes no sense. Everybody has said so to whom Glendora has presented it. It is even not good English composition, let alone atrocious law and fact. What was the Appellate Division motivation? It was the same group as took Glendora off TV in the first place, November the 12th, 93. Galata, Pickman, Nassau Republicans who did not want Glendora reading their bad but true record on TV every week. Presiding Justice Guy James Mangano lives in Great Neck. The same people who took Glendora's program off TV before November 12, 1993 are the same people who pressured the Appellate Division to try to get it off again. The paper the Appellate Division wrote is so bad because they wanted to rule against Glendora but didn't know how. So as always, they grabbed some paragraph from defendant's bad brief and latch onto it. Mr. Callagy has not produced the insurance agreement of Cablevision as he was ordered to 5 times in the Judges Bryant Fox courts, January, February 1996. Glendora pleads the Judge Silverman court make him produce the Cablevision insurance agreement. It is basic discovery, Article 30 CPLR. Glendora has had 14 appeals before the Appellate Division. They never rule on the merits, they never rule on the law, they never rule on the fact. They always rule on whether they like you or not. They do not like Glendora because she has exposed them on TV, because she has rallied against them along with 20 others outside 45 Monroe Place. because she let the world know that Judge Thompson said to a lawyer as he stepped up to the lectern, "Tell me the truth, you're here because the lower court beat the H-E-double-L out of you." Glendora has monitored the Appellate Division 2nd Department 40 times. The last time Guy James Mangano, the Chief Judge, screamed, hollered, and shouted at a lawyer presenting an oral argument. Glendora videotaped a half hour of the 100th anniversary of the Appellate Division 2nd Department. January 2nd, 1996, interviewed Judge Mangano and got good audio and video of Judge K on the big TV screen. It was all positive, and Glendora had it on cablecast on Nassau Cablevision so Judge Mangano could see it in his hometown of Great Neck. The Judge Silberman decision order of July 28, 1994 was the big decision that made the front page of the New York Law Journal, 5 columns of the New York Times, full page in the Long Island Newsday, and 2 issues of the Westchester Law Journal. What Mr. Callaghan told Judge Silberman March 11, 1996, Monday, was either poor memory or lies. Callaghan thinks Glendora versus Kofalt was before Glendora versus Cablevision. No, Glendora versus Cablevision was the first lawsuit. It was filed on December 6, 1993. It went to the Second Circuit U.S. Court of Appeals on March 18, 1994. Glendora versus Kofalt Cablevision was filed on March 7, 1994 in New York Supreme Court. It was decided July the 29th, 1994. It went to the Appellate Division, 2nd Department, August 28th, 1994. The third lawsuit was Glendora versus Dolan, March 28th, 1994. Judge Bryan overruled Judge Broderick's decision. One thing Judge Broderick said was that Cablevision was not a cable TV operator. $3 600-watt lights, meaning $66 plus the tax, don't work. 3 lanterns don't work. We don't have any light. This is starting a new videotape, 6S, and we're reading to you on page 11, Mr. Kofalt was fired from Cablevision in March 1994. He now lives in North Carolina. He was the highest a non-Dolan ever went in Cablevision. His position as corporate president has never been filled. So what Mr. Callaghan was telling Judge Silberman March 11, 96, Monday, was all backwards. But Judge Silberman would not give Glendora a chance to set the record straight. Judge Bryan has already ruled that Glendora has a private right of action to enforce 47 United States Code 531. No cable operator shall exercise editorial control of the public use of channel. This is your channel. It's a public channel. No cable operator which is the same law as Article 28 of the New York Executive Law 829.3, the one by which Judge Silberman put me back on the TV, and now the Appellate Division is trying to get me off of TV again. Mr. Callaghan attempts to make something of the Judge Broderick decision, but Judge Broderick overruled the same. See the March 24, 1995 minutes from the Judge Bryan court. Glendora has seen Judge Silberman as a guest of Judge Bryan in the new $33 million courthouse, once when it was first opened and Judge Bryan invited all the state judges for lunch, and twice when the courthouse was dedicated November 13, 1995. Callaghan had another memory lapse, unless it was a lie. He thought he had submitted franchise agreements to the Judge Silberman court. He never did. He submitted some to the Judge Bryan court. His memory, that is Callaghan's, is hopeless. Mr. Callaghan is going to try to cover up what Judge Bryan has ruled. A, Cablevision admitted Glendora's right to be on Nassau TV by putting her on TV 6 weeks before trying to take her off, or before taking her off. B, Glendora's residency, public within, makes no difference. And C, Glendora has a private right of action to enforce these 2 laws. Glendora's trial against Cablevision was to start March 4, 1996. Callagy sent Judge Bryant the appellate division order. February 28, 1996, Judge Bryant stayed the trial and also denied Callagy's order to show cause why Glendora's subpoenas for witnesses should not be vacated. Judge Bryant also refused to vacate Glendora's subpoenas on Galata and Picken, Nassau County. Glendora also won compensatory damages, and Judge Bryant denied Cablevision's motion to stay discovery, and this was all on July 19, 1995. Judge Silverman said, March 11, 1996, Monday, he did not care what happened in federal court. This is unreasonable. As Judge Van Graflin ruled, if there is a conflict between the federal and state laws, the federal laws must prevail. That was his order on January 11, 1995, Glendora versus Cablevision, and that order is enclosed in the paper sent to Judge Silverman. Was a stack this high. Glendora versus Cablevision, U.S. Court of Appeals, Second Circuit. Glendora tried repeatedly to present her facts and law March 11, 1996, Monday, but Judge Silverman constantly interrupted her. Mr. Callagy spoke the rest of the time. This is unfair. Franklin is Glendora's witness, and the minutes show the record. Glendora evokes the record of Judge Silverman's hatred of Glendora, screaming at her in the hall, ripping her off the victory costs of July 28, 1994, the duplicity with his sheriff not to collect the gag orders Glendora's rallying in front of the Grove Street Courthouse, June, July, and August of 1995. Judge Silverman's blocking Glendora from his courtroom in violation of Judicial Law Article 2, and Glendora's complaints about the same to Judge Trafficante et al. Something is wrong. Not Judge Silverman, not Mr. Callagy, nor Glendora had a copy of the odious appellate division decision order. Trooper Nancy Carlucci came up with one, and this seemed to be the first time Judge Silverman had read it, as he read it that day at the bench, March 11, 96, Monday at 9:30 a.m. Franklin took 4 pages of shorthand and lost $32 from work to witness, and here's 1 page of his notes. Page 17 and 18 are his reports. Those are Franklin's shorthand notes. At 9:25 a.m., Franklin writes, Callagy came into the courtroom through the back door. We had just seen him in the 16th floor hallway about 9 a.m. He was out there making points with the judge ex parte, which he shouldn't have been doing. But he's crooked. Glendora saw Koza in the courtroom at 9:32 a.m. and went over to say, Koza, you owe me $30. Judge Silverman looked at Franklin at 9:35 a.m. Silverman said he didn't have a copy of the appellate division decision here. It's in the chambers. Callagy was quick to have his say. The questions, he said, are whether the plaintiff qualified as a member of the public within based on the franchise agreement, and if the plaintiff has a private right of action. On the first question, Callagy offered, in order to qualify, you must be a member of the public within the town. Don't you believe it? Judge Bryant ruled all against that. Callagy continued, what happened here, we had come in on a motion to dismiss, and the plaintiff asked for injunctive relief. It's all backwards, folks. A suit in the federal court before Judge Broderick was dismissed, and the Second Circuit affirmed the decision. An identical action was filed with Judge Bryant and was dismissed. This is all wrong. These are all lies. It's all bad memory. But this panel of the Second Circuit was unaware of the earlier ruling of the panel of the Second Circuit and remanded the case to Judge Bryant. Now Judge Bryant has stayed all proceedings until the outcome of this proceeding. It's all wrong. Legal issue is not an issue of fact. I think this is Silverman speaking. You, Glendora, claimed a right that was adjudicated. I had no choice but to recognize your right to be on. There was misinterpretation of what the something is. There weren't any issues of fact. If there weren't any, then there isn't anything there. Judge Silverman says. This sounds like Callagy, the appellate division, would like your court to resolve it. Judge Silverman, taking a cue from Callagy, then you'd like to have the court decide this summarily. Judge Silverman, it doesn't matter what happened in federal court. This was nothing to do with the federal court. It doesn't matter, Callagy says, because he lost in federal court. If he'd won in federal court, that's all he'd be talking about. Glendora said Judge Bryant saw Silverman's decision as unassailable. He was shocked that the appellate division would do what they did. This is Franklin reporting on what happened March 11, 1996, Monday in the Judge Silverman court. Judge Silverman, if the lower court judge makes a mistake, the appellate court will reverse it. So we will see this the same way. In directing that papers be submitted, Silverman said, you don't have to say a whole lot of things. The issue will be brief. It is not brief. He assured Glendora she could respond to Cablevision papers. He gave Cablevision 2 weeks and then Glendora another 2 weeks to respond. He listed March 27th for the papers to be to Glendora and the court from Callagy, then April the 12th for Glendora to respond to Cablevision and the court, and by April the 19th, Patriot Day, everything should be fully submitted. But then Silverman said the case will be fully submitted April the 19th, then decide the issue on the papers. Glendora tried to get in a few words. I would like to say, do you agree with the appellate court's decision? Silverman, they are always right because I have to respect their authority. So it doesn't look very good, does it? Glendora pressed that Callagy did not bring up the public within in your court. He cannot bring it up for the first time in the court of review. Silverman says it is not for me to review their decision. Then by Silverman, whether I agree or disagree with their decision, that is their decision, and the decision has to be abided by. Glendora persisted. No issues of fact, just issue of law. Cablevision admitted my right to be on their system. Judge Silverman put it in writing. Glendora, the franchise agreements were not submitted in your court. They were not a factor. Judge Silverman, all the arguments in writing. He wouldn't listen to me, but he'd listen to Callagy. It was grossly inadequate. Now here from Judge Bryant's decision of July the 19th, 1995. It is undisputed. Judge Bryant decides that beginning in September 1993, Glendora's video program was broadcasted by Cablevision on its public access channel serving Nassau County. Cablevision thereby admitted her right to be heard on public access. This court concludes that Glendora's residency does not bar her use of Cablevision's public access channels or application of Section 531E. No cable operator shall exercise editorial control over public use of channel of the Cable Act to this case, especially in light of the sponsoring request of M.S. Mondesando. So this is public color. This is public access. This is public channel. The public owns this. You own this. Professor Perry, New York University Law School, said this morning, March the 13th, 1996, Wednesday, that if he could find the time, he would seek leave of Judge Silverman to file a brief as amici curiae with Brian D. Craigman when Glendora's brief is due April the 12th, 1996. Cablevision's Operation Channel 25 public access is an exclusively governmental function. This is state action, and they acted under color of state. Further, it was, we're up to page 20, the Galata Pickin Republicans who pressured Cablevision to take Glendora's program off TV to get rid of the bad but true reports of their dereliction of duty. It was hardcore political speech censorship. It was an intentional violation of her guaranteed rights under the federal and state constitutions. Glendora is entitled to nominal, compensatory, and punitive damages. The March 23, 1996 minutes from the Bryant Court show you that Callagy Cablevision lost on collateral estoppel and moot. These minutes also show that Bryant said they would keep Glendora on TV and not take her off again. Harry says that he's a stockbroker and he gets sentimental at Christmas time. He hangs mistletoe over the door so his clients can kiss their money goodbye. And vacation time is when millions of Americans go beyond the Rubik cubes and they try to refold a road map. And Diane said, Mom, is it true what the Sunday school teacher said, that we come from dust and we return to dust? And the mother says, of course. And Diane says, well, I just look under the couch, Mom, and somebody's coming or going. We are reading you page 21 of Glendora's memorandum to Judge Silverman about his unfairness on March the 11th, 1996, Monday, conference. Glendora says about the franchise agreements, Callagy never supplied the Judge Silverman court. Glendora says what United States District Judge Barrington D. Parker said is right. You mean the franchise agreement with the village carries more weight than the federal law I am here to enforce? These lawbreakers, Cablevision, Tata, Quinn et al., are billionaires, making a big lot more than judges and law clerks. This case is of immense public importance, as Judge Silverman has said, Judges Minor, Van Grafen, McLaughlin, Judge Bryant twice. Mr. Callagy lost the Joan Collins case with the same type of lying he presents to the Judge Silverman court and to the Judge Bryant and Second Circuit courts he lost in. Mr. Callagy cries Judge Silverman converted Glendora's cross motion to summary judgment, and Callagy did not have time to submit papers, but it was Callagy, Kofalt, Dolan, Tata, Quinn et al. who fled from Glendora's discovery. That was their chance to tell what they knew. Glendora pleads this court compelled discovery that plaintiffs submitted and that defendants were fugitives from. Callagy, Dolan, Kofalt, Tata, Quinn et al. Lied about discovery from May the 1st, 1995 in federal court. Glendora asked Judge Silverman, do you watch Chat with Glendora on TV? Glendora sent Judge Silverman copies of her briefs and Callagy's briefs to the Appellate Division, 2nd Department, February 1995 to May 1995. Leave that alone, the brief. Did Judge Silverman read? Judge Bryant, on February 28, 1996, Wednesday, when he stayed Glendora's trial of Cablevision lawbreakers, said, off the record, you know Judge Silverman is not going to change his mind. March the 11th, 1996, Monday, Judge Silverman said Judge Bryant taught him something, but it was unclear what Judge Silverman meant. Glendora did get an opportunity, March the 11th, 96, Monday, to ask Judge Silverman, do you think the Appellate Division is right and you are wrong? Judge Silverman said the Appellate Division is always right. How can they be right about this mess? And here is this atrocious decision by the Appellate Division, 2nd Department. That would be Judges Sullivan, Santucci, Friedman, and Krausman. They, as I say, they were influenced by the Republicans in Nassau County who want Glendora's program off the TV because she keeps reporting to you the truth of their dereliction of duty. Those Republicans being Galata and Picken. 829.3 and 594 are concise and cryptic. No cable TV operator shall prohibit or limit or exercise control over public use of channel. Franchise agreements, the public within, have nothing to do with this. They are afterthought lies of desperate Callaghy when Gardner already stated on November the 12th, 1993, Friday, at 4:50 p.m. that the executives and corporate were taking the program off because they did not like the content. This is the issue for the Appellate Division. Perverted. This is the issue that the Appellate Division perverted. Judge Magness said public access is a public forum on September 20th, 1994, a limited public forum. Brian Grafman has the audio tape of the same. This was at the oral argument, 2nd Circuit, and to Mark Fowler, the former FCC chairman, who lost Grafman, Perry, and Glendora on Cablevision. Glendora asked for costs on this referral for modified to this court by the Appellate Division, 2nd Circuit. 2nd Department. Then we have to face the ugly fact that the Appellate Division, 2nd Department, like Judge Silverman, loathe, hate, despise, and abhor pro se's. But remember what the 2nd Circuit said about dismissing a pro se's case. In view of the well-settled rule, particularly applicable in pro se civil rights actions, that a complaint should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of her claim which would entitle her to relief. We're up to page 28.